You're here for a number of reasons. Any objection calling them together from the people?
None from the people.
Mr. Reagan, any objection?
Objection.
Right. Mr. Carr, you have, as stated, 3 matters.
Warning, you are not going to like this defendant.
2 different judges, and these are on the following case: 240-59054, People State of Michigan versus Isaiah Anthony Carr, also known as Isaiah Carr. Case number 240-59055, People State of Michigan versus Isaiah Anthony Carr, also known as Isaiah Carr. And 240-59061, People State of Michigan versus Isaiah Anthony Carr, also known as Isaiah Carr. Here.
Good afternoon. Steve Vincent for the people on all 3 cases.
Your Honor, right on behalf of Mr. Carr, as to all 3 matters, waiting for reading, stand mute. Advisors.
Thank you both. All right. On all 3 matters, court waive formal reading, enter a not guilty plea. On case 240-590-550, I'm scheduling 2 court dates, Mr. Carr. September the 4th is a probable cause conference via Zoom, 8:30, Judge Giles. You have a right to a preliminary examination September 10th, in person, 8:30, Judge Giles. The other 2 remaining matters, case ending in 0610 and case 0540, both will be waived formal reading and are not guilty plea. Both will be scheduled on the same date, time, and location. Probable cause conference Tuesday, September the 3rd, 8:30 via Zoom, 36th District Court, Judge King. You have a right to a preliminary examination in person September 10th, following Tuesday, 8:30, 36th District Court, Judge King. Did you hear and understand those court date and times, Mr. Carr?
Yes, sir.
Judge King must be back. This is the 2nd day in a row I've heard them sending cases to him, which I think is a good thing.
Not guilty, please. Waive formal reading on all 3.
Your Honor, can I just say something real quick? So the exams are they at different times, Your Honor, on the 10th? Just want to make sure they're both scheduled for the 10th. Yeah.
All right. One moment. So we have different PCC dates, but we have the same exam dates. Back, if you want to do the 11th. Thank you, Mr. Reagan. I seem the same. The one Giles, do we kick that back to the 11th? Okay, so on the matter scheduled to Judge Giles in case 240-590-550, that preliminary examination will be moved till September the 11th. So on the Judge Giles case,
That's good to hear. I hope you're right, Fletcher boy. I think Judge went too far and made a mistake, but his heart was in the right place. And I thought there was, I understand it, but I thought there was a bit of overreaction to it.
September 4th, September the 11th, on the both of Judge King's, September 3rd, September 10th.
He's generally a good judge.
Waive formal reading, not guilty plea. Ask the bond on all 3 matters from the people.
Is there a specific way you want me to handle this, magistrate?
No. If you want to address generally bond together, that's fine. If you want to get specific on the case.
You know, I like me some Steve Vincent, and he is he's not having this defendant's shenanigans, and you'll understand why.
We can do that, and then we can address one at a time. So you proceed at your pleasure.
Okay, I just wanted to ask. I think the way that I will do this is I'll go chronologically from the oldest case to the most recent, if that's all right with you as well as Mr. Ray.
Absolutely.
The oldest case here we have is that May of 2022 defendant being charged with criminal sexual conduct 1st degree. People are asking for remand. Allegedly, the defendant and complainant were having sex in that incident. The complainant didn't want to have any more sex with the defendant. The defendant felt otherwise, ended up proceeding to put his arms around her neck, ended up pinning her arms, and then he ejaculated in her. And then she became pregnant. And Judge, she currently has a PPO against this defendant right now, even though the incident was in May of 2022.
Oh yeah, we've got 2 more charges. It gets worse.
So I think that's quite telling. She's in fear. Allegedly, the reason why she didn't end up reporting this to police until after the incident, one was she didn't think she was going to get pregnant, but two, based on an APA note, there was fear and emotion that was running. So the CSC first degree, where he impregnated an individual that said she didn't want to have sex anymore, we're asking for a remand. Regarding the November 16th of 2022, the criminal sexual conduct, 4th degree, 3 counts. Just to get into, the allegations here, allegedly we have a defendant who was unconvincing in his attempts to persuade the complainant, and the complainant in this one being his first cousin, to allow him to give her oral sex. He wasn't persuasive in his attempts so he could give his first cousin oral sex, even though I guess he was trying to gain her trust by telling her that he had previously done that to a number of other cousins of his. So because she turned him down and refused, he got on top of her and then started rubbing her chest, and then started rubbing the lower,
I warned you,
private area of the female, judge. And a police report was made the next day regarding this individual. We're going to be asking for a $50,000 cash, no surety, tether house arrest in that. And then we have the most recent case, July 10th of 2024. Where the defendant's being charged with an armed robbery. We're asking, this is the first, we're asking for a remand on this as well. So 2 remands and a $50,000 cash, no surety, tether house arrest. In this particular incident, Judge, we have the defendant who enters an apartment where the complainant's located. Complainant's like almost 30 years older than him, points a firearm at the complainant, takes the complainant out of the apartment, down to the complainant's vehicle, all the while still being armed, and then assaults the complainant nearby his car in the parking lot, punching him and then hitting him with the firearm that he allegedly is armed with. He knocks the complainant out, and then he urinates on the complainant. After knocking him out, he urinates on the complainant, then robs him of his wallet and of his keys, Judge, and then he takes off. And in this particular instance, we have green light video that captures a lot of this incident. We have eyewitnesses who saw this defendant beating this individual and then urinating on him. And then we have the defendant who ends up admitting that he was at the incident scene when the assault took place. So respectfully, Judge, we're asking for remand in that, remand in the CSC first, $50,000 cash on the 3 CSC 4th degrees.
Thank you, APA. Vincent, response, Mr. Reagan.
So Judge, let me start with the oldest case. From May of 2022, I wouldn't note the complainant and Mr. Carr were in a dating relationship. They were having, consensual sex. And even the complainant will say it was consensual at that time. And it's alleged that she told Mr. Carr to stop. He did not. Now, I just want to make it clear, it's never okay for somebody, when they say no, for somebody to continue. I just want to be crystal clear. Now, Mr. Carr tells a different story. That is not what happened, and that's not how it happened. So obviously, Mr. Carr is saying that it was consensual. It was never a situation where that occurred. Now, the complainant ended up getting pregnant, and I would note that, Mr. Vincent stated that, there were a couple reasons why, she didn't report it right away. And the first being that she didn't know that she was going to get pregnant. I don't understand how that could be a reason why someone wouldn't report a rape because they don't feel like they're not going to get pregnant. So I'm not sure really what that situation is about, Judge. And Mr. Cardell's a different story. We fast forward a little bit to November of 2022. And by the way, Judge, just going back to the May 1st, 22 case, that warrant was just signed today.
Yeah, I signed it.
Yeah, you signed it today. It was just signed today. Going forward to the November 16th, 22 case, that warrant was signed yesterday. Now, that was an allegation made. It's a CSC4, a 2-year high misdemeanor. He has, I think, 3 or 4 counts, and that he actually was touching his cousin inappropriately, Your Honor. That's something that Mr. Carr denies, the way it was written up, the way the incident happened. But obviously, again, that's something that's going to have to play out in court, with that situation. He also has a armed robbery case, Judge, that, we're going to have to deal with as well. That is something that Mr. Vincent spoke about, talked about how they have green light camera footage of certain situations. And Judge, always.
I'm sorry, Mr. Reagan. I think defendant has something to say. He's trying to talk. He was trying to talk.
Yeah, well, hold on. He's not going to be able to talk right now. Just hold tight.
I like that. Mr. Vincent's all into this case, and he's like, oh, I think the defendant wants to say something, and I really would like him to do it. Of course, his defense attorney wisely puts an end to it, but he but it didn't stop Mr. Vincent from taking a shot at it.
Yeah, don't talk. So,
sorry.
I just want to, say there's some green light stuff, Judge. And I note that always just preparing cases, Judge, we look at a lot of different aspects of what evidence is, how it's presented. Mr. Carr has a version. He has a side of what happened, how things occurred. And a lot of times, and that's the reason why, Judge, these investigators' reports are hearsay and they're not admissible as evidence, because they don't always tell the whole story. Obviously we're not looking at getting personal bonds here, Judge. I'm not going to be unrealistic and think that, he has 3 cases, but I am going to ask the judge for something reasonable. I don't think remand is necessarily appropriate here. I think that, my client, he works every day, 6 a.m. to 7 p.m. at TMI Traffic Management. He does have a child, Your Honor. And obviously these are serious matters. Mr. Carr takes it seriously. We're going to fight him. We did talk about matters earlier today, Judge, and his version of what actually happened. And there's some things that I think are going to come out to his benefit in some of these matters. So I'm asking the court to set reasonable bonds in these matters, Judge, and not to remand Mr. Carr at this time.
Thank you both.
Yeah, I don't believe anything Reagan's saying either, but he's doing his job. I give him credit. That's a tough thing to defend, and he what else can you say? My client's got a different version of it, and those things aren't true. That's the essence of what he said, and that's all you can say, and that's legally sufficient. I don't believe that after a hearing that will be the result, but that is the only reasonable thing you can say.
Mr. Carr, I've heard advocacy for both parties. I've reviewed the investigator's report on each, having signed the warrant on at least one of these matters. The court is well aware of these allegations and extremely concerned regarding the safety of the public. We have sexual assault of allegations on a number of people, and as apparently family members included. The court has heard advocacy on the case ending in 9061. As stated, I have signed the warrant on this allegation. The court notes that the allegations is you strangled this complaining witness, sexually assaulted this complaining witness, where the point that she became pregnant based on the sexual assault. And we have an allegation Subsequent, that was the first allegation. The latter is in July of 10th of 2024 in case 0550. That allegation, sir, it's alleged that you were to have assaulted an individual, stole his property, urinated on him while he was unconscious. The court notes substantial injury resulted as alleged to these allegations, including but not limited to injuries to his face, completely swollen shut left eye, which can be apparently observed on one of the officer's body camera. There's, as indicated by the APA, there is apparently green light footage that shows evidence to support this allegation. On both of those matters, the court finds on each that there is a likelihood of conviction. On each of those matters, the court finds that the presumption of guilt is evident and great. And for each matters, the people have asked for a remand. And given the nature of these allegations, which are life offenses, given the likelihood of conviction, the court does find you by clear and convincing evidence to be a danger to the community. And you have a number of pending charges. And for those reasons, you will be remanded on both of those matters as requested by the people for further proceedings. During these remands, you will have absolutely no contact with any complaining witness. On the case ending in 9054, I also have reviewed the investigator's report. This is another sexually assaultive allegation against your family member. The court does find there to be a likelihood of conviction. The court, in order to set an unaffordable cash bond, and given the pending matters, and given the information presented on record by both parties, must find by clear and convincing evidence that you are a danger to this complaining witness, who was apparently a teenager at the time. You being in your 30s, the court finds, given these assaultive allegations on a family member, sexually assaultive allegations on a blood relative, as well as the information alleged on the investigator's report, given a likelihood of conviction, court has concerns regarding the public in whole and this particular complaining witness. And by clear and convincing evidence, I find that you're a danger to the public, given the likelihood of conviction and the number of assaultive allegations sexually included throughout the investigator's report and the remaining two pending matters. And for those reasons, I'm intentionally setting an unaffordable cash bond on that matter. 50,000 cash surety is recommended by the people. On this matter, there's no use of alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon. No contact with court's address in Hampton, Georgia, or no contact with the complaining witness, Ms. Carr. Has no contact of any kind, orally in writing, through a third party at her place of residency, employment, or through any forms of social media. Prior to being released, you'll be filled with a GPS tether, placing you under house arrest. If you go anywhere near that complaining witness, it's a violation of the court's bond, subject to get you picked up without a warrant, have your bond conditions forfeited and or revoked. Do you have any questions on any of your court dates or any of your bond conditions? And Mr. Reagan, before you say anything, Mr. Carr, that 50,000 cash surety is unaffordable?
Yes, Judge.
All right, so on that.
The wheels of justice are going to roll you right into the Wayne County Jail.
Sorry about that. Good muting. Good muting. All right. Well, we have that one's out of the norm. Sometimes that's all I can find, but if they're interesting, I'll do them anyway. That one was obviously super intense, and I was worried. I was worried the judge was going to go weak on it. Not specifically that judge, just any judge. And just I don't know, just because it's Detroit, and just say, oh well, we don't know yet. Let's just let them out until we have a hearing, But that's not what happened. That's not what happened. The right thing happened here. But that was intense. I was watching that, and he has the 2 SA allegations, and usually these people sort of follow a pattern. I'm no expert on the topic. But then the third thing was also horrific, but different. I don't know. Some psychiatrists would probably come on and say, "Nah, it's a power issue, and it's all the same crap." I don't know. I don't pretend to know, but it struck me as different. And just, I mean, this guy's nasty with range. Like he'll just do anything bad that comes to his mind. Apparently, they've got video of it, or video of portions of it at least. I'm sure it's not great, but because it's not set up for that. But like, if you get some portion of that he should be going away for a long time. When I see stuff like that, I'm no expert on this. I'm just like, okay, that's a broken unit. There's no fixing that. The only thing we can do there is separate from society. That's it. I'm all for rehabilitation. I like a good comeback story and all that. This guy, I don't know. Maybe if he sits 20 years and finds religion or something. But currently, this guy is a defective unit that needs to be removed from society. The end. I don't know what else to do. Maybe we can revisit in 10, 15 years. But for now, he's got to go. It's as simple as that. And it looks like that process has started. Prosecutor was all over it. Defense attorney, and that's a beautiful part of the system. The defense attorney, Reagan always makes us crazy, and I get that. Sometimes I think he goes too far. I don't think he did here. I think he just made the appropriate arguments. Sometimes he's a little loose with facts, in my opinion. But that's not what he did here. He's saying my client tells a different story and these things didn't happen this way. I don't think that's what a trial or testimony will bear out, but that's certainly what his client's telling him, and that is the only position to be taking at this point. So even while that's frustrating to hear someone accused of those things defended, even in a sense, it's the right thing. It's the right thing. Both attorneys were doing a good job. The judge did the right thing. There you go. My God, it's a nasty appearance, but I guess I'm giving the seal of approval to this particular court appearance in Detroit. The right thing happened all around. The prosecutor was all about it. Prosecuting it vigorously. The defense counsel was doing everything he could under the circumstances, and they were bleak. They were grim for him. And the judge made the right call. Yay, justice system. I say that mockingly, but I actually mean it. I actually mean that. That's where we are. All right, there we go. Now somebody send me some fun clips so I can get this out of my mind. Thanks for coming out. Sometimes I do that. It's just what happens. This isn't Disney here. That's a real court case that happened today in Detroit, and I'm commenting on it. Because I'll get pearl clutchers in the comments. Oh yeah. Oh, I don't like the facts of this case. Well, I'm sorry. I'm sorry. I didn't make the facts. That's what rolled into court. That's life. And we have to put our big boy pants on and deal with it. That's it. I actually found it very interesting. All right. Somebody send me some fun stuff and I'll come back and make it all up to you. Thanks for coming out.